So, apologies for the slight delay, but of course, I mean, that's very much, this is very understandable because, of course, coming straight from the ICJ and then over here takes a bit of time, especially after the huge well, in any case, the powerful intervention that you gave earlier at the ICJ. So let's start. It's my pleasure, in any case, to welcome you all in The Hague in my capacity of director of the Grotius Center for International Legal Studies, which is Leiden University's teaching and research hub on public international law. And we're located both in Leiden, the academic heart of the university, and in The Hague, where the community of practice is active. So, of course, I don't have to tell you that this is a very special day, despite also being Friday the 13th. So let's forget about that, because, of course, much more importantly, it marks the final day of the oral proceedings at the International Court of Justice with respect to the advisory opinion in relation to climate change. And I hope that you have been able to follow these proceedings, whether in the Peace Palace, but most likely through UN Web TV, the greatest intervention, the greatest invention in years. If you haven't seen the IUCN intervention, I would highly recommend. As I said before, it was a very powerful intervention and really worthwhile to watch back. So again, a warm welcome to you all, whether you are here in person or joining online. For the person joining online, if you can't properly hear us, then please leave a message in the chat. Let me extend a special welcome to our distinguished guests and panelists. First of all, Grethel Aguilar, who is the Director General of IUCN. Of course, I think you all know what IUCN stands for, but International Union for the Conservation of Nature. Next to her is Christina Voigt, who is chair of IUCN's World Commission on Environmental Law. Then we have Francesco Sindico, who is co-chair of the WCEL's specialist group on climate change. Together, also known as the IUCN Dream Team, representing IUCN, of course, at the hearings today. And last but not least, Liliana Joreg, I'm mispronouncing, Joregui. Fine. Director of IUCN, the Netherlands. So without taking up much more of your time, it is my pleasure and honor to invite IUCN's Director General, Grethel Aguilar, for an opening statement.
Thank you. Thank you very much. And thank you to all of you for being here on a Friday night. So thank you so much for being here. It's especially nice for me to be here in Leiden University because my son graduated from here. So I'm sure he's watching. So today marks an extraordinary moment on our collective journey towards climate justice and environmental accountability. It was incredible to be at that court. I can share with all of you. It has been really a privilege for IUCN, the International Union for Conservation of Nature, to present our arguments before the International Court of Justice on what is truly one of the most pressing and biggest challenges of our time. And you can say that is the triple planetary crisis of pollution, biodiversity loss, and climate change. But actually, for the ones who are lawyers and for many people around the world, really the most pressing and consequential issue of our time is the legal responsibility of states to combat climate change. And these proceedings were about exactly that. What are the legal responsibilities of the states to combat climate change? I was privileged to be in the team composed by Professor Dr. Christina Voigt and Professor Francesco Sindico, who I only have to thank a million times for the incredible work that they have done, not only to prepare for the proceedings today, but for all the work done previously, because we also submitted a written statement. And as you know, you are now studying here, that's a lot of work. So I know that they did it with a lot of passion and of course, with all the knowledge that they have within them and through the IUCN Commission of Environmental Law. So in the courtroom, alongside nations and organizations from many different parts of this planet, we made a clear and unwavering case. States have binding legal obligations under international law to address the climate crisis. These obligations enriched in the Paris Agreement, customary international law, human rights treaty, and other instruments are not abstract ideals. They are real. They are responsibilities to act, to protect the vulnerable and to protect the people that are most vulnerable, to preserve ecosystems and to safeguard this planet that we all depend on. Failure to act has consequences for people, for nature, and for the very systems on which human life relies. And those systems are based in our nature. So if we don't protect nature, we don't have a future. It's as simple as that. Today, we emphasize the accountability, that accountability is not optional. We don't have that luxury at this moment. Accountability is not optional. It is a cornerstone of global climate governance and a critical lever for justice. As my colleagues, Professor Christina Voigt and Professor Francesco Sindico, so eloquently argue, states must act urgently to reduce greenhouse gas emissions, limiting warming to 1.5 degrees, and provide reparation where harms has occurred. But some of you probably watch the proceedings during this week. And let me tell you, I mean, in a personal note, that I was really taken by the statements of small development nations. I mean, if you saw the proceedings, perhaps you as me could really feel it. I can tell you a lot of things here today. I'm a lawyer like many of you, and I can go on and on about the details of the law and why the Paris Agreement is important and why we need to link the Paris Agreement with all the environmental international conventions and human rights. But what really took my heart and my mind were the statements of the small developing islands. They are at the front of all of this. They are first in line. And if we want to talk about justice, equity, and doing the things right, then we have to go back to the differentiated responsibilities, common but differentiated responsibilities that we have in this planet. As a UCN, we are proud to stand at this moment, bringing together, of course, what a UCN is. And what a UCN is a union. We just not brought the three of us to court. What we brought to court was 1,400 members, 17,000 experts, and the hopes of many people around the world that believe that nature plays a fundamental role and that believe in the well-being of people. And that also believe that we are in a crisis where we have no time to lose. I think that the word justice really comes to place here. And just think about everything that is happening. And also, I call all of you for, to have hope also. Because although the situation is where it is, I think that these proceedings, and I said in my intervention, can also bring us hope. Can bring us hope that finally, even though this is an international court and the opinion will not be binding, I think that it could make an impact. And we have to believe that this opinion in 2025 will be powerful, that judges around the world will use it, that you in your own places, in your own future jobs will use it, and that what we are doing is the right thing to do, is to put nature at the table, is to put people at the table, and to believe that we cannot live in a planet where we all can prosper. So thank you.
Thank you very much first for this reminder, of course, of what is at stake, but also for speaking of hope, because of course, hope is one of the most important things that we can cherish, and of course, there are sufficient positive signs also, right, that states want to do better. So let's hope indeed for the future. The next person that is, okay, let's go. Yeah, okay. Yes, no, I will do it. Yeah.
Thank you very much.
Let's see.
Yeah, okay, I'll just start. So, really happy to be here with all of you. I just spoke 5 minutes and I am really tired. I have no idea how Christina feels now. But I'm really, really happy to be here and happy to have a conversation all together afterwards. I just have, can you make it big?
What?
The slides?
This more slide? Yeah.
Yeah. So I just have a few slides, don't worry, I'm not going to give any lecture or anything,
No,
but
that's not. Okay, so now I post the screen share. Yeah.
really this is for the very few, and if you all have it, just you can fall asleep for 30 seconds, framing what actually happened today. So the whole idea is that we were and we will be, when the decision comes out, not in front of an adversarial case. This is not state versus state. This is an advisory opinion that comes from a request from somebody. I'll get to that in just a second. So you may have heard it often. It will not be legally binding, but very morally and legally persuasive. We can discuss that in the discussion, what that even means and what will be the implication. So you all know the questions by now, by heart, up and down, right and left, probably. I think it's important, however, to understand that there's a lot of politics in this question. This question was adopted by consensus, which seems incredible. Every single state who was there in these 2 weeks agreed word by word to this question, which is why this question is so broad, which is why this question for some will work and for some will not work. But it is important for those of you who, again, may not be on a day-to-day basis involved in these proceedings to understand that what has been asked to the court is, yes, 2 legal questions, but negotiations, fierce negotiations have happened at political level to get these questions. And it goes without saying that we always have to thank an incredible group of students from the University of South Pacific who dreamt of this day in 2019. And if you saw them this morning, it was a really moving moment when one of them had the opportunity to actually talk before the court and realize that dream. So the Director General already said something about this, but this has been a marathon, not just the last 2 weeks, as we were saying, Christina, but for a year and a half, if not more. These are all the steps that have happened. IUCN doesn't just go into the ICJ because the ICJ calls us up. We had to request to participate. And I can tell you, we were not the only ones. So one of the great things is that we were actually authorized by the court. And have a look at the other international organizations. It's interesting, most of them are regional. European Union, the Pacific Islands Forum, and so forth. we were very unique, not just because of who we are, the members and the numbers that Grethel already mentioned, but also because there were very few that were really, really global to some extent. So we really played an interesting role, I think, in that. So once we were requested to participate, was authorized, we had our first glass of wine, but then we said, oh my, now we actually have to do this thing. And as you will see later, really, it was a lot of analysis, definitely, but a lot of coordination as well. And we were able to provide a very solid written statement in March 2024. Then I really think if you want to have a look, the written comments of IUCN, I think, are really good, because we actually did refer to other people's statements. Now, I don't want to put out names there, but I've seen some of these written comments, which were re-emphasizing what the country said in the first place. And I don't really think that's what the court wanted. So I do believe we did a good job there. Obviously, you saw us all live literally an hour ago or something like that. And we'll all wait very impatiently for the decision coming out next year. So it wasn't just me, Christina, and Grethel. IUCN very kindly gave the task of leading this effort to the World Commission on Environmental Law under the leadership of Christina. And then WCL created a core group of some 12, 13 members that you have the list name. I hope I haven't forgotten anybody, but those are the group of people who really worked hard and from all different time zones, from all different parts with me and Christina. And obviously we had Grethel joining us as counsel today, but we also had a wider advisory group within especially the climate change specialist group, who I have to thank for their help. We had amazing colleagues from the WCL steering group who also provided comments and feedback. And again, we want to thank them for their work. And obviously the IUCN Secretariat gave us your feedback and colleagues from staff. So I emphasize coordination. That was a lot of people to get together and to work well together. But we made it, we delivered a strong oral statement, and obviously we're very happy with it. I will leave just showing the core group in person. One had to be here, but I don't see him, but a few are somewhere around The Hague. But I really want to thank each and every one of them from the bottom of our heart, both emotionally, but also academically or rigorously, because we couldn't have done it without them. All the legal stuff, Christina will tell you about it, and then we'll join in the discussion afterwards. Thank you.
Thank you very much, Francesco, also for showing first, of course, that this is really an exception where you say that most of the organizations were actually regional, and IUCN, of course, with its broad membership, but also being global in nature. And of course, I imagine the only organization that actually represents nature. And of course, for the enormous work that's, I will do it. The enormous work that that was in it. So thank you for introducing us to that. And of course now, Christina, we're looking forward to the nitty-gritty, but also the very important legal stuff.
Okay, let's see.
Let's see what you remember.
Let's see what I remember. Because I just said to Francesco, when did you do that? I mean, that's probably why he was walking here. Well, first of all, thank you so much for coming here. As Grethel already said, on a Friday night, we don't take this for granted. So you must be really interested in what happened at the court and what IUCN did. But before I start with the nitty-gritty legal stuff, I also would like to express some words of thanks. Well, first to our host here, Professor Daniela Dam-de-Jong, who is, of course, a professor at the University of Leiden, but she is also a co-chair of one of the specialist groups of the IUCN WCEL. And now I always run into a problem because you have such a difficult name. It's the specialist group on security,
environmental security and conflict law.
Environmental security, we have to change it. And every time I introduce you, and I have to do it from the top of my head, like, oh, what was it? But yes, so thank you also to you and Karen Helm, who's the chair, for your very important work you're doing for the IUCN on environmental security and conflict issues, which are, of course, of dominance as we speak. Thanks also to the IUCN Netherlands National Committee, Jesus Christ, for being here, for helping us, organizing, for speaking later. It's wonderful to cooperate with you in this event. And of course, many thanks, Grethel, for putting your trust in us that this somehow ended up today with the intervention at the court. As Francesco said, it was a long journey, but it was wonderful to have the support of you, Grethel, of your staff at the IUCN Secretariat. Have your back in a way, because it's a difficult endeavor. So thank you so much. And also thank you for having been here today and carrying our flag as the opening speaker. And then to Francesco, I mean, he showed you the pictures and, you know, all the people involved and this huge group and all the different bits and pieces, but he did the coordination, right? He was the one who would draw everything together, and that over quite a long time, in addition to, you know, all the normal jobs that we have in our daily life. So thank you so much, Francesco. It's been an amazing journey and a wonderful cooperation and collaboration with you. Thanks so much. To the whole WCL core team, and I hope some of them are online listening to us, for their work, for their dedication, for their many hours in those year and a half. Francesco also mentioned we have written submissions, we have written statements. If I understood the court correctly, but correct me if I'm wrong, the statements will be made publicly available now at the end of the proceedings, right?
Yeah.
Maybe they're already available. Okay. So we had to wait until today, until the last word was said and the judges left the room, that our statements or everyone's statements become publicly available. Until now, they were confidential and we couldn't talk to anyone about what we actually said and without breaking that confidentiality rule. So you're the first, other than the public in general who listen to us, to whom we actually can explain and express what we did and what we said in our statements, both written and oral. We also did 2 other proceedings. There are 3 parallel advisory proceedings. There was the one at the International Tribunal on Law of the Sea, where IUCN also participated with a slightly different group, but it was also coordinated by WCL. And we also participated in the advisory proceedings at the Inter-American Court on Human Rights, where we're still waiting for the advisory opinion to come out. So it's been a lot of work for the last several years. But as Grethel said, it's very important that IUCN is part of these proceedings. We definitely had the feeling at the International Tribunal on Law of the Sea, but also today, that the judges listened. They listened when we spoke. You could see that they made notes, they underlined things. Whether that also translates then in their opinion, that's a different question. But we did, I think, gather the attention of all the judges, which is a hopeful sign. So what we presented there today, we all had only half an hour, as you all know, was kind of a very comprised version of our statement, which is much more longer and much more complex and refined than what we were able to present to the court. And we also only picked some particular issues, as most of the delegation did in their oral proceedings. Maybe I can run you to a number of key points, and there will be questions, time for questions afterwards, I think, where we can discuss some of the things and you can ask more specific questions if you want to know about, particular issues in more detail. But maybe, Francesco, if you can go back to the questions put to the court. So the questions were put to the court by the United Nations General Assembly in the resolution adopted in March 2023. So that was what guided, of course, what framed our work, because, of course, what we said, we wanted to answer those questions so that our input was relevant to the court when the court needs to answer those 2 very big and general questions. Now you will see that the first question was dealing with the issue of what are the obligations under international law, state obligations under international law to protect the climate system and other parts of the environment. So the first exercise we did was to delve into this question and try to understand it, because it's not so easy. There is so much in it that it was also for us first an exercise of interpretation of that very broad question. And the first thing we did is what is actually the climate system? Because from that everything kind of flows. And here we are in a positive, in a very fortunate situation, because the climate system is defined in the United Nations Framework Convention on Climate Change, Article 1 or 2, where the definitions are. And it's legally defined as the totality of the atmosphere, hydrosphere, biosphere, and geosphere and their interactions. So if you read that definition, there isn't really anything left out of the climate system, right? If it's the hydrosphere, the atmosphere, the geosphere, the biosphere, and everything that interacts between those, it is a very comprehensive term. So we made the decision that we only look at the climate system in that very comprehensive understanding, but we didn't really delve deeper into that second part where it says, and other parts of the environment, because in our understanding, there wasn't really much left of the environment. Once you define the climate system, that's pretty much it. So we focused on legal obligations to protect the climate system. Now, if some of you are lawyers, international lawyers, you know what the sources are in international law. They're defined in the statute of the ICJ. So you start with international treaties, and then you go to custom, and then maybe in general principles of international law. So you start with treaty law, right? That's the most specific reflection of what states actually committed to with respect to whatever they want to do, but in this regard with respect to climate change. And that led us, of course, first and foremost to start with to the adopted treaties that we have. And there to the most specific treaties, which are the United Nations Framework Convention on Climate Change and the Paris Agreement adopted under the convention. And we delve really deep into what are the legal obligations under these agreements, in particular the Paris Agreement. And you perhaps heard me talking quite a lot about the Paris Agreement. Now, why did we focus so much on Paris? Now, if you had a chance to listen to states' interventions and international organizations, you probably saw that they kind of fell in maybe 2 or 3 camps. There were some that were very critical to the Paris Agreement and said it means nothing and helps nothing. And then there's another camp who said, well, Paris Agreement is important, but it only has procedural obligations. It's only purely procedural that states need to send in their NDC, and everything is up to their own discretion. But if you actually read the text of the Paris Agreement closely, you will see that there is much more to it. And I have to admit, I was a negotiator of the Paris Agreement, so I do know the history of many of these provisions. There is much more to it, which also negotiators had in mind when they negotiated the Paris Agreement, that of course there are nationally determined contributions, but states have to put them forward every 5 years. It's not like once the NDCs are ours and are not good enough, Paris doesn't work. No, this has to happen every 5 years. And every 5 years, those NDCs have to wrap up in their level of ambition to their highest possible ambition. So we try to rebut those states who said, everything is procedural, you can do whatever you want, it's all to the discretion of states, because that's a wrong reading of the Paris Agreement. And the court will have to deal with the Paris Agreement. It has no chance to just say, no, we don't look into Paris. It will have to deal with it because it's the most specific treaty that we have on climate change. So that's why we did spend quite a bit of time on it to give it the flesh it actually needs and deserves. But there's something else with the Paris Agreement, and that it reflects the global standard of where to hold climate change. Because we know climate change is unavoidable. It is happening and it will continue to happen. The real core question is, at what level can we try to hold it? But what is the acceptable level that allows humanity and our systems to still function? And this is what we find in that agreement about 1.5 degrees in the Paris Agreement, which is not a scientific agreement. It's not a scientific target. I actually traveled here from Kuala Lumpur, where I attended an IPCC meeting. And the scientists are very clear, because they said, well, scientifically, you could perhaps say that you should stop warming at 1 degree or 0.5 degrees. But 1.5 degrees is a compromise. It's a political compromise that was then included in that agreement and is now endorsed basically by every single state. So that's a very important element. And we argue that this element, this standard, is also something that informs as an interpretative tool other obligations under other international treaties and customary law. And then the final word on Paris is that it doesn't only set that 1.5 degree guiding standard, it actually also tells us what needs to be done to keep warming to 1.5 degrees, because it talks about the pathways and timelines. Like, how much time do we have? What is the emission level? And that's where net zero 2050 comes in, but even net negative thereafter. That's all part of the Paris Agreement, and it can be interpreted and read out of its provisions. Now, Paris is important, but it's not the only thing. It doesn't exist in isolation. There is much more around Paris in international law that the court will also have to consider. But you perhaps heard that were also some states who said Paris is the only thing, right? It's lex specialis, the most special law. It's actually, it says that the whole phrase is lex specialis derogat legi generali. It means lex specialis sets aside the more general rules or general laws. So when you argue with lex specialis, it also means nothing else is applicable if something is the most special rule. Many states, I don't know, I didn't count all of them, but you could hear that argument several times saying Paris is lex specialis, nothing else applies. We rebutted that very strongly, saying Paris does not exist in isolation. There is much more else in international law that is equally important and applies to climate change. In particular, the Law of the Sea Convention. Of course, we know that from the International Tribunal on the Law of the Sea, which rendered its advisory opinion in May this year. Very, very important opinion that came from that tribunal, which is based in Hamburg. But also human rights law, also the Convention on Biological Diversity, which we did not address in the oral statement, but also the Montreal Protocol on substances depleting the ozone layer, and many other treaties that have a relationship with climate change. Just one or two words on the Law of the Sea Convention. Maybe some of you have worked on it. The Convention on the Law of the Sea is a mammoth of an international treaty. If you have ever looked at it, it's enormous, big. But it's from 1982, and it doesn't mention climate change, right? When parties negotiated the Law of the Sea Convention, they did not have climate change in mind or greenhouse gas emissions. So what is so important that came out from the International Tribunal on Law of the Sea is that the tribunal said, well, actually, greenhouse gas emissions made by people, by man, anthropogenic greenhouse gas emissions, they are actually pollution of the marine environment. Very important finding that greenhouse gas emissions are pollutants of the marine environment. And because of that initial finding that they are pollutants, the whole set of obligations under the Law of the Sea Convention was opened under Chapter 12, or 12, which is to prevent, reduce, and control pollution, because once it is defined as pollution, states have the obligation to prevent, reduce, and control that pollution, but also to protect and preserve the marine environment. So the International Tribunal on the Law of the Sea found that states have these obligations. These are due diligence obligations where you have to, put forward basically your best effort. But the Law of the Sea Tribunal also interpreted the Convention on the Law of the Sea in the light of the Paris Agreement, because otherwise you wouldn't really get to 1.5 degrees and the threshold that is needed to halt climate change and to net zero emission by 2050. So that was a very important move that that tribunal did. And we suggested to this court to do something along the same lines. And that's also important to create harmonious reading or harmony between different treaties so that they don't conflict with each other. This was something we put to the court, as many others did as well. And then human rights. Again, on human rights, perhaps you heard it, the views went into all sorts of directions. Many states, in particular those most vulnerable to the impacts of climate change, and Grethel talked about small island developing states who really brought their case home to the court by having pictures, very emotional stories, brought it home how devastating the impact is of climate change on many of their interests, their rights, but also on human rights. So it was very important for us. Both Grethel expressed that in her opening statement. I took it up later, but we have a huge chapter on human rights in our written statement that states do have obligations under human rights law, which are for example, the Covenant on Civil and Political Rights, but also the Convention on the Rights of the Child, and many of the other international, but also regional human rights treaties. They establish positive obligations. That means states must do whatever they can to create an institutional legal framework to protect human rights against the impacts of climate change. And it applies both to taking mitigation measures, reducing greenhouse gas emissions, and adaptation measures, because climate change is happening and human rights need to be protected at all levels. And adaptation measures, for example, building seawalls or protective water reservoirs or whatever it is equally important. We did refer to an earlier decision by the European Court on Human Rights and Klimaseniorinnen against Switzerland, which maybe you have heard about, where the European Court was very clear that Switzerland in this case violated its obligation by not taking sufficient and enough measures to reduce its greenhouse gas emissions to net zero by 2050, more or less, to shorten this a little bit. So that's something we brought to the court as well. Also, we pointed to the need to take also future generations into account, right? When you talk about human rights, we think about here and now is important. But the more we see that climate changing or climate impacts are intensifying, and they will intensify, the more detrimental will be the impact on those that are either young today and live into a future which will look completely different to what we're used to, or those that are not born yet, right? Future generations. That was a very important point. And you perhaps see in the first question, there is a reference to future generations, right? What are the obligations of states under international law for states and for present and future generations? So that issue is put squarely to the court to say something about how to deal with future generations. So that was treaty law. So if you look back into the statute of the International Court of Justice, after treaty law, you come to customary international law. Now, if you're not, and I hope not everyone is an international lawyer here, we have a bit of a broader audience, but if you come to customary international law, you have to know that this is something that is not written down anywhere in a treaty. That's something that exists because states believe that they're bound by these norms, and they actually have a fairly consistent practice in doing so. It's a bit of a tricky thing in international law, but it is a source of international law, which the International Court of Justice will hopefully base its opinion on. Now, when we look to that unwritten customary international law, there are a number of binding norms that we were able to identify. And again, this was a very contentious issue, which divided many parties into two groups, where many parties said, or focused almost entirely on customary international law, particular small island states. And then you had very strong interventions, I think, by the EU, no, not by the EU, by the UK and the US. I don't want to call out particular states here, but in their argument, they would say customary international law does not apply in this context. In particular, there is a rule in customary international law that says that states have to cause significant harm to the environment of other states or of areas beyond national jurisdiction, for example, the high seas. So that was a very contentious issue, and we argued very strongly that customary international law applies to the protection of the climate system, that the rule of preventing significant harm applies, that it's a due diligence obligation, but that the question of when significant harm actually occurs is something that is based on science, and it will happen once warming crosses over 1.5 degrees, and we're already there, but it can already happen on a lower degree of warming, but it depends on the particular circumstances of a case. So in sum, we put forward to the court the argument that at the very core, every state has to do its very best, its utmost to protect the climate system, but that's an obligation that is relative to states' responsibilities and circumstances. It doesn't mean that every state has to do exactly the same thing, but every state has to do as good as well as it can, basically. Now, the second question I will spend only very little time on. The second question deals basically with the situation. So once we know what the obligations are, what are the consequences if states don't comply with them? And were you supposed to talk about this? No, not now. You talked, you had your 5 minutes in court. What happens if, I just want to make sure that I'm not, what happens if states don't comply with those obligations when they breach them? And a breach of an international obligation in international law, it's called an internationally wrongful act, if it can be attributed to a particular state. This is all very hard legal lingo. But if there is an international wrongful act, that gives rise to state responsibility. A state is responsible if it has acted wrongfully. And in that whole universe of state responsibility, there are certain consequences that arise. For example, states have to seize the wrong act. They have to do the right thing. They have to stop doing the wrong thing once it was established that they're breaching an international treaty. They also have to guarantee that they're not going to do the wrong thing again. Guarantees of non-breach or non-repetition of breach. I'm sorry, non-repetition of breach. They also have to then, if that is established, have the obligation to make full reparation of their of the damage that they caused, including also compensation, restoration, or satisfaction. And of course, for many of those small island developing states and vulnerable countries, that was a core point, right? That they're quite strategic and also very clear that once the court established exactly what the obligations are, maybe in the second step, we may see a contentious case by some of these states in the future. We don't know yet, which most likely will focus on compensation. So that's one of the reasons why these proceedings are so important, because in the future they could lead to a proceeding where a state claims to get its damages and losses compensated under this regime. So we just said this applies, but it cannot be identified in the abstract, right? In order to give, to claim compensation and then give compensation, you have to know exactly what the case looks like. And this was not a contentious proceedings. This was just paving the way for whatever comes afterwards. Well, we hope that the court and the judges found what we had to say and wrote interesting, but I hope that we were able to give a little bit of an input that united those different perspectives, right? There were really different camps going in all directions, and I think it's fair to say that we tried to put forward something in the middle, which hopefully the court will find helpful.
Thank you very much, Christina, which after such an exhausting day, I can imagine, and not just this day, because of course, I mean, this was the culmination of a lot of work today, but that you are still able with so much enthusiasm to give such a clear expose of both IUCN strategy, but also the applicable law itself from the NDCs and the level of ambition, and that they have to be progressive as substantive obligations also, but also the interrelationship between the Paris Agreement and other agreements in international law and customary international law. I'm particularly curious about what the court is going to do with the latter. So the relationship between Paris and customary international law, but we will have to be a bit patient for that. This concludes the first part of this evening. What follows next is that we have a roundtable that is chaired by Juliana. And after that roundtable, there will be possibility for questions. So.
Thank you. Daniela. Let me start introducing myself. My name is Liliana Jauregui. It's a difficult name, sorry. But I represent IUCN the Netherlands, the Dutch Committee for IUCN. And of course, the IUCN family, part of the IUCN family, but we represent the 37 members of IUCN in the Netherlands. And for the second part, as Daniela explained, we're going to have a session of questions for like 20 minutes to dig deeper in what happened. I'm not a lawyer, so I still have a lot of questions. What are the politics, etc. So I have some questions. And after that, I'll ask you to think of your own questions. We will have time enough to do it, like more than half an hour, so be patient. And so first of all, Francisco, Christina, I would like to hear what your insights, what are the reflections that you have after these 2 weeks of negotiations.
I go first?
Yeah,
I can relax a
yes.
bit?
Yeah.
First of all, it's quite liberating that you can applaud after a speech. After 2 weeks in the court, it felt so weird, you know. Usually we're there at last. So anyway, I'll try to be very brief because I'm really keen also to hear from all of you here. What I felt after 2 weeks of trying to follow as much as I could is that you could really see how countries were dividing themselves in camps, in different groupings. And I felt it wasn't just law, it was also politics. Yeah. We also always have to remember that when you arrive at this level of international law, politics is never far away. And I could really see groups like most of the SIDS, but then you had a few of the SIDS slightly different. You had, if you want, the BRICS, you had other countries, more developing countries, and other developing countries, developed countries that felt the Paris Agreement was something, other developed countries that felt the Paris Agreement was something else. And I'm very curious to see how this division, whether it is just an ICJ thing or whether it filters in other fora as well. So that's the not so legal, let's say, thing. From a legal perspective, I think there were so many things that were said. You saw the question before. You could take it as you wished, and you could just develop it as you wished. But I definitely think, as also Daniela said, the relationship between Paris Agreement and customary international law, which may seem very academic, but actually has huge practical implications, especially vis-a-vis potential future liability disputes. And then the never-ending discussion about common but differentiated responsibilities and respective capabilities in the light of national circumstances, if you want to put that in as well. And clearly there were some very different camps there. So I'll leave it to that, Juliana, but I really think let's never forget that this is also political. I saw different camps developing, and Paris, customary international law, and CBDRC, not the only ones, but some of the very, very high level takeaways, if you want.
Yeah. So it's always a lot about politics, of course. I'm very interested to hear more about the camps, but let's move first with you. Christina, what are your insights?
Well, I subscribe to everything Francesco just said, but I've been following the climate negotiations for now 20 years. And I've been to every COP since then I was a negotiator for many years. And I could see many of the same positions put forward in yet another forum, right? While in the negotiations, you try to find consensus by putting forward your arguments. So at the end of the day, you arrive at some sort of common agreement where not everybody is happy, but that's the way multilateralism works. You see now many of the same arguments being put forward in this forum, right? Where you not, or at least not the parties arrive at a consensual agreement, but that's now put to the court. Which is of course very, very difficult for I guess for those judges now to find that middle ground based on law. And of course all the parties in the climate negotiations, they make their statements based on their political priorities and their needs and so forth. But here they frame it as law, right? Here they say this is the law, and then the others say this is the law, and that is the law. But it's a very interesting development coming from the negotiation background to see, you know, the same arguments on CBDR, on compensation, on loss and damage, on finance being put forward in this forum. But it's going to be super interesting to see what the opinion says and how then the opinion feeds back into the multilateral negotiation process. It can help, right? It can help to put this a little bit on a more speedy train, but we don't know. That really all depends on what the court comes up with.
Yeah. So, Grethel, we were also speaking about hope. But you still have hope. I admire you for that, because following all these lines of position and repeating the same arguments in different fora, you can also say, well, this is also going the same direction. So how do you see the hope for the human rights and the nature protection? How are they going to be maybe pushed forward with this? What are your insights?
Yes, no, thank you very much for the question. I think that one of the most important parts of these proceedings at the International Court of Justice is the opportunity actually to link climate change and human rights. I think that while some states argue that this is just about the Paris Agreement, we heard the countries, especially small developing islands and developing countries, talking about how much they're suffering and talking about real situations. It's not the long political speech about, oh yeah, no, our islands are going to disappear. No, they actually were talking about problems related to health, to the possibilities to be fit. It's just so real that I think that is undeniable. So to keep saying that climate change is just about the Paris Agreement and the small line that the Paris Agreement has about human rights is just inadmissible. And I just hope that these judges can see it. No, that it was very interesting, because at the end of the oral proceedings today, there were 4 questions, and coming from the judges. And one of the questions really caught my attention, and I was happy with the question, because
You were ready to answer it.
Oh, I was ready to answer it. No, they put the questions and then they gave until 20th of December to respond. But I'm on the 4 questions. Yeah, the time record. No, now before Christmas, there are 4 questions I put to the ones who participated in these proceedings. But the question was about how do you actually link what is already in some treaties and also in constitutions around the world about the right to a healthy environment and the right to a clean and healthy environment and the human rights issues, like the rights to culture, the rights to health well, the right to life itself. So they were asking about, okay, it's a nice speech, but from the legal point of view, how do you link these two? I was ready to answer, no? Because actually, it's so clear. I mean, we have the instruments. We have the UN Declaration of Human Rights. We have customary international law. We have so many other treaties, not just international, but regional and national laws. So for me, the question was really a no-brainer, because we do have the legal instruments. What is happening, in my view, is that there is resistance, huge resistance, to link climate change dispositions with human rights and environmental law. This is like, for some, is a non-go area. Why do I have hope, Liliana?
Yeah, that was a question.
I do have hope because I really have hope that these judges finally can, explain to all these countries and also to civil society that this link is possible, but it also exists already. And I think that I was happy when the judge asked the question, because I hope that this means that it will be a part of the opinion later in 2025. So yes, I do have hope. And I think that all of us need to keep insisting in this. And for you, the ones who are here, the ones who are connected, I really believe that is us, the human beings in this planet, and especially the ones that are in difficult circumstances, that we need to keep insisting. Not one time, but all the times that we need in this, in different conferences, in different scenarios, but certainly in IUCN. I mean, we cannot lose hope. We need to say it again and again and again, and until, there is no more again, because we achieved what we needed to do. And I have hopes that between all of us, and I have hopes for the judges that hopefully they will do the right thing to do, because this is the right thing to do. It is the right thing to do. It's so obvious that it's the right thing to do that I hope that after a whole week of hearing, 2 weeks, sorry, 2 weeks, 2 weeks of those judges hearing states, regional and international organizations, something must have touched their hearts and their minds. So I do have hope. If you hear that the whole 2 weeks, perhaps you will join me that it is impossible that a human being, particularly those judges, will have not been touched by what they heard.
Beautiful, thank you so much. That's like a closing remarks almost. I still have more questions, but I think that would be a good, I would like to look also at the audience, and maybe they have questions already. See, if I have more, but I would like to start interacting with the audience. Can you say your name also?
Of course, yeah. Jason Roddle, I'm an assistant professor here at Leiden in the Grotius Center. Yeah, I have a question about reparations and how specific you think the court might be on this. Perhaps taking into account some of the things like the African Union said on debt relief as a form of reparation or satisfaction, at least. Yeah, curious to hear your thoughts on that. Thank you.
You want to collect some questions, or shall we?
Yes, because I'm also having questions from the audience. I was completely forgotten about the people online, so I'm collecting those questions, and you go ahead.
I would be very surprised, if they go in that level of detail. And that, I think, is where question 2 becomes tricky. because the moment you start going into specifics, you're almost, I'm not saying it does have to, you're almost starting to think of a scenario. And I doubt that they will go in that. I may be surprised. But what I do have to say is that, I mean, think about it. There were 2 weeks, 98 states, 12 international organizations, 15 judges, 4 questions. For somebody who doesn't follow ICJ, you may think, surely they must have had more questions. Come on, after 2 weeks, you know, or domestic law, you know, all the cross-examination. Actually, from an ICJ, that's quite a lot. And some of them I found, and let's think of the reparation aspect. The first question from the American judge, if I wrote it down correctly, that was, you know, what is the obligation of a country within its own territory if they have fossil fuels? It's massive. It is absolutely mind-blowing that could be dealt with. That's much more than transitioning away from fossil fuels. I mean, so it's interesting, you know, then you ask yourself, why did she ask it? I mean, is it because the court is interested in that area and they will pick on parts of the proceedings? Who knows? But I think, you know, even more than the reparation aspect, which debt relief to me was absolutely, it's crucial for cities. Leave aside climate change, just development, I mean. But I would be very surprised if they go on that level. Stop there.
Thank you. Are there any other questions? Yeah, you see, there are many questions, so I'll keep taking those first. Oh, go ahead, your name, question, and maybe both of you together.
Okay, thank you. Nadia Sanchez, a proud graduate from the Rocha Center. I did my LLM and PhD here, and I'm happy to be back. I'm an international lawyer. I run my own consultancy based in The Hague, and I have worked as legal advisor during climate negotiations. And I am very curious to know how this, not only the opinion, but also what we have heard in these 2 weeks, the presentations and the submissions, could influence negotiations and positions within that framework. And I was wondering, listening to some of the presentations on the standard of due diligence. Yeah, and perhaps for you, Christina, how could that influence what the court says, what we have heard so far, and what the court might say about it, due diligence later in the advice, the opinion itself, could influence the way parties comply with the Paris Agreement and the work of the PAIC. I was curious of the Paris Agreement implementation and compliance committee. Yeah.
So we'll take the next question as well. Sure.
Thank you, and thank you so much for all the work you've put into this pleading. My name is Jana Planemets. I'm the guest researcher here at the Rocha Center. My question actually builds up on this one and mainly relates to the possible impact that the advisory opinion might have in relationship to the customary nature of some of the rules that have been argued as crystallized from the treaty law into a custom. You've mentioned several times that there have been divisions among member states, in particular in relation to that nature of a custom in international law. And do you see that might also divide judges in finding customary law? From my perspective, that would be one of the key contributions of the advisory opinion, even if not legally binding, is in a way a source of interpretation of the law and should be used in national proceedings, as you mentioned, Christina, in some of the possible pleadings asking for reparations from environmental harms and climate damages. So what is your impression? How would that generate from all that you've heard, and what could be your expectations in that regard? Thank you.
Maybe I start with that. Nice to see you. And very good question, and really a difficult one, right? It really depends on what the judges are going to say. I mean, if we look at ITLOS, right? What ITLOS did was interesting because it said, yes, they're independent obligation under the Law of Sea Convention, but at its very core, it was informed by the Paris Agreement. But the judges said states have to take all necessary measures to get down to net zero CO2 emissions by 2050. So it imported this kind of, or interpreted UNCLOS in the light of the Paris Agreement. And I think that most likely is the right way to do. What could be really dangerous would be to establish alternative standards, alternative requirements, because then you confuse states, right? Then they have the Paris Agreement and they do things under the Paris Agreement, but then they have another standard under customary international law or human rights law. And then by the end of the day, you have 3 or 4 more competing standards, and states can pick and choose. And I think that is a real danger. And that's why many states pointed so strongly on the need to harmonize and coordinate between different treaties, so not to create. So if the court does it, if it follows ITLOS approach, it would not then hopefully create an alternative standard, and that could be helpful into the Paris world and the negotiations and hike, because it may actually push parties to do more, to do better as they are required. But it's a difficult situation, because many states expressed frustrations with the COP process and that the current NDCs are not yet at the level of ambition where they need to be. And that's the whole point of Paris, right? To get there. So it's an interesting dynamics between the frustration that many, particularly small island developing states, had now in Baku with respect to the new quantified collective goal on finance, which they thought would be more, and then less, and that played into the statements before the court now very prominently. But yeah, I think if the court uses Paris to inform other treaties, then we may avoid that kind of chaos. But we don't know what it's going to do. On custom, your question, I completely agree with you. I mean, the court is asked to clarify what the obligations are, right? It's not there to create new obligations, or that's not the court's role. And if it were to do so, it would get in a really difficult situation. But it's really important to clarify what the obligations are, in particular in custom. And that customary norm to prevent significant harm to other states and areas beyond national jurisdiction has never been applied in the context of climate change. Never. And you've probably heard that some states argued it cannot be applied because we have this accumulative harm and it's global, and the rule initially was just from one pipe to a river, or let's say transboundary context. So the court clarifying that this actually applies to climate change, I think that would be an enormous step forward and very helpful, I think, in whatever comes afterwards. And I don't think the court cannot do it. I don't think it cannot do it. Yeah, well, I think it can do it. No, right. I think the court will have to go there and
If I may, and we may discuss this later, my sense was that even those states who did not look at custom or said it was more the lex specialis thing. It wasn't really that they argued this is not customary. And I think where they were arguing the accumulative nature and force on the responsibility side. So I think there was a kind of argument there. So yeah, it will be interesting to see what they say about custom international law. We'll see.
The online audience is also a large one, and they're also bringing some questions now. I'll take the one, Leonard de Klerk. He is a lead author in the initiative Accounting of War, Researching Climate Impacts on Armed Conflict. The question is not directed to one. Are you reading it?
I think no. I'm looking for Danielle.
So the question, I'm not sure if it's But it's about,
I'll let Daniela also expand.
yeah,
You-
Yeah, okay. So I have to admit, I haven't read the Palestinian intervention yet, but I knew that they were bringing this up. And of course, I mean, if you look at the military, they are an important source of greenhouse gases, right? So whether that's the conflict in Gaza or the conflict in Ukraine, they are an important source of greenhouse gases. So in principle, it matters, right? Addressing that, whether the court will actually do so or say, well, let's focus on the more general issues. That I have no idea, to be honest.
I think they won't. But I also think that if they were to address every single thing, that the 98+12 organization will have an encyclopedia, not an advisory opinion. So there's also that. At some point, they will probably really take the two questions and look at the arguments that were put forward, say, this is super interesting, but I don't see the connection with the question. And that's for the judges to decide.
so I'll take, no, I'll go with my question now because it's going very much into the lawyer side and I'm not a lawyer. I have a question for Grethel about, so how do you see the future of the climate governance and why do you think that these three COPs have to work with each other?
Thank you. But be careful because I'm a lawyer.
I'm not a lawyer, so try to. I'm not a lawyer.
You know, I have participated in the last 3 meetings or conference of the parties of the 3 major environmental conventions. So biodiversity, the CBD, then the climate change in Baku, and most recently, last week, I was in Riyadh in the UNCCD convention on desertification. In each of these conventions, you hear the same speeches, more or less, and in the same line. Oh, the 3 Rio conventions must work together. It's like a national anthem or something like that. But then you have to ask yourself, what exactly are we talking about? I mean, is it that the conventions now need to have just one meeting, as many people want, and with different sub-houses, and instead of doing all these meetings around the world it's super expensive, it's not very climate change friendly, et cetera. But I always thought that it's not just about the meetings. It is actually about looking at this problem in a different way. Not dividing. Well, we have this certification problem, then you put it in one box and then you try to fix it. And then you have the loss of biodiversity. In IUCN, we just did the assessment of 160,000 species, and a quarter of those are at risk of extinction, which means that we never gonna see again these species. Then I don't have to explain, the implications of climate change that we're talking here. But this tendency of talking about the problems in different houses. And let me add human rights here too, because we keep thinking that if we solve the problem in one house, then it will disappear. But actually, we have to have this systemic way of thinking where we can understand that our actions, have an impact on everything we do. And our actions have an impact on this planet, we like it or not. We don't need 1,000 international conventions. We don't. We don't need to keep talking about, let's coordinate. We just have to understand that the way we are doing it is not working. It's definitely not working. But we have this opportunity to do it differently. We do. And I believe that if we do it differently, if we start talking about climate change, nature, and human rights as one house, then perhaps we will faster achieve what we need to achieve, which is this, to maintain this beautiful planet alive for all of us. But sometimes, because of what we have been doing for many years, to change is a big deal. But I honestly think that we don't have the time to keep going to this conference of the parties to say that yeah, we need to coordinate, we need to work together. You know, in the last climate change COP, I asked the team of IUCN to erase the sentence from my statement, because every single delegation was saying that. And I said, no, if we're gonna say something, let's say something that matters. Let's say how we're gonna do it, or let's make the link between all of these and explain why we have to do it and how we're gonna do it. At least be brave and put a proposal on the table. Because there are nice sentences everywhere that everybody repeats, but that actually without real and factical action, it's not going to change anything. And I'm sure you all know those places: triple planetary crisis. Let's coordinate between the 3 Rio conventions. Let's stop that and let's say what we're going to do and how we're going to do it.
And there is one more question online. I don't know who of you wants to answer this one. It's about the enforcement with this, non-binding.
I mean, in a way, and that's why we framed it at the beginning. It's obviously not legally binding. This is an advisory opinion, so it cannot be enforced. It should not be enforced in a domestic legal kind of mentality. So we're not talking about that kind of judgment. However, and this is what we all hold, is that this being the UN highest judicial body, this having the gravitas, if you want, that it has, what will be said will be very persuasive. Now, the word persuasive is very tricky, because it depends. You may be persuaded by something, but not me. So then it becomes a bit personal as well. So then it really becomes who's going to actually use the advisory opinion. Will it be other international judges? Will it be domestic judges? Will it filter down in the multilateral process in whatever magical way? Or will it not? So again, I'm not answering deliberately because you cannot answer the question. But depending on your strategy, whether you are a civil society organization or whether it's an international organization or country, you will want to use what comes from the ICJ in order to persuade your positions. But obviously you'll need to do it with a very in-depth legal analysis and not just, out of the blue. Yeah.
And in the same line, Francisco, how do you think, I'm taking the floor now because I have one question about the situation in the Netherlands where I have this litigation climate cases. How do you think this advisory could also somehow influence or help, or maybe not, this process?
So obviously for those of us who work in climate change litigation, arriving in the Netherlands, it's a bit like arriving in a playground. It's like you've done everything before everybody else and you do more and everything. I think the interesting thing that doesn't happen only in the Netherlands is that we are slowly moving from the Urgenda kind of cases against the state to the ING, to the KLM, to the more famous one, the Milieu Defense Shell. And that's where it gets juicy in a way, because it's really going to hit the pockets in a way. But you would think, well, but this is another world. I mean, today was states, international organizations, judges of the United Nations. This has nothing to do with private actors and operations that lead to greenhouse gas emissions. But then just 2 things. One, look at our own statement. I'd say 25, 30 seconds before you gave me the floor. there was a part in your part where you referred to the fact that this is relevant for private actors. That states, in order to comply with their due diligence, have to also consider and enforce and implement activities that will have an impact on private actors. So that's the first hook, if you want, that may also help or not here in the Netherlands. And then the other thing, let me go back to the first question of the judge. I mean, if she's asking what are the state obligations of a country that has a lot of fossil fuels in their, I mean, some countries will be okay, national oil companies, but not in all of them. So there you're talking private actors, I'm sorry. So there is going to be really interesting for the private actors themselves to say, ooh, I hope they don't answer this question in one way, because then it will be interesting in the future Shell's case and so forth in the Netherlands, but also in any other.
But I would like to add that, one aspect that is very important is that these opinions, although, of course, we want other judges around the world to use them, especially if the opinion is a good one. And we also need to understand that can also be a tool for civil society. It's not just about, the interests of the private sector or if the judges are going to use it or not around the world, but it's the power that civil society can have into the courts. I mean, how many times civil society has been standing for days in front of courts, asking for things and demanding, and like it or not, having an influence. So I truly hope that this decision will be one of those, that normal people that is affected by climate change can use it and can say, no, actually, I'm here because the International Court of Justice had this line that I believe that you, judges in whatever country, need to apply. So I have that hope that this could be a tool also for civil society. The situation is so much in a crisis that people are looking for solutions. So hopefully this could help.
Thank you. So we are almost at the end. There are several, well, maybe no one from you.
The last round.
The last round. I think there is one online.
Yeah, there's another one.
I think we have to also.
Yeah, I know. Oh, there's a lot.
Yeah, I know.
Okay.
They're coming now. So, but I want to give preference to the ones here.
Yeah.
Now, I think there are one and two. I see you both, right? If you one and the other.
I don't know. Right. Yeah, actually, it's a nice segue. Thank you so much. I'm Julika. I work with WWF. I think some of my colleagues have been reaching out in the process. And many of my questions have been answered already by what you just said, and by answering questions, and especially the last part, like what can civil society organizations do? Quick reflection, which I think was also already answered by what you said, Christina, on when we watched it today. Of course, the expectation probably was that more mention of other environmental agreements would be part of your statement. You said it is part of the written submission, but I see that it was really a strategic decision, like what to bring orally in front of the court, and obviously you were able to see what other countries were preparing. So that leaves me with, so we've talked about consequences already, or you shared a bit of insights. And I'll just, because I'm not a lawyer, I'll just make use of legal expertise here. I was struck by another intervention today, and I know it's a long-standing discussion in those circles, from the Pacific Islands Forum. He was talking at length about statehood, which obviously is a very urgent question, but I was wondering, is that something that this advisory opinion will actually deal with? I personally know that the judges were really interested, everybody was looking up, but then is it in your view, is it in the scope of this advisory opinion, especially since
yeah, there's UNCLOS and probably it's where adjustments are needed. So yeah, would be grateful for your views.
Thank you.
Okay, Daniel from ITLO. Thanks so much. It's been a really wonderful way to, I think, digest everything after 2 weeks of oral hearings. I have 2 questions. I'll try and keep it quite brief. The first one is, one thing that's given me hope has been the ITLOS advisor opinion. We've had 6 to 7 months now to digest what was a unanimous decision. How influential do you see this being in the ICJ? Because surely it would be very hard for the judges to go against what they said in Hamburg. And also, I didn't see very many of the states who were, in the pro-Paris Lex Specialis camp really dealing with ITLOS on the merits and trying to distinguish it. And the second question is a bit more lighthearted, but were there any arguments, either written submissions or oral submissions, that you thought were really surprising or creative or really just, made your eyes widen? You take that how you will. Thanks.
Yeah, well, let me start and then you can first on nature. Indeed, we have, of course, much more in our written statement and the comments on all sorts of things, but also how to bring nature into the climate treaties, but also what is under the Biodiversity Convention, right to a clean, healthy environment, rights to nature, everything is there. But today we made it a strategic decision, as you said. So I can just refer to our written submission, 200 pages, on nature, which is now finally out. And I'm really happy about this because we've been sitting on this document for half a year or something. So now it's out. Daniel, on ITLOS, yeah, that's a really interesting one. We of course hope that the judges here follow ITLOS. I think those states that mention ITLOS mention it in a very positive manner, right? Appreciating what the tribunal did in Hamburg in different aspects, also that harmonization aspect that I mentioned. And because of that positive attitude towards ITLOS, and I haven't heard, maybe 1 or 2 states were a little bit critical, but the majority, absolute majority who mention ITLOS mention it in a very positive setting. So I think that may spill over to the ICJ, and we can only hope that this is going forward. But if the court were to adopt the ITLOS approach, it would have to do the same then with human rights and customary law. It can't do it like this systemic interpretation just for law of the sea because ITLOS did it, and take a different approach for other areas of international law. I think then the court has to be consistent with other stuff. So that's going to be interesting to see whether it adopts the same methodology and then applies it in other contexts. One word on statehood, and then you do more words on statehood. I was wondering the same. Does it actually fall within the questions, statehood, the continuity of statehood, protection of maritime zones and all that? If you interpret the question in a very wide way, it could fall in. But I would not think the court is going to go there, but we don't know yet. But as I said earlier, this is also a forum to state your interpretation of the law, your position. It's also a forum to create opinio juris, which is one aspect of creating new customary law, right? State making legal statements in international fora is part of creating opinio juris. And I think that was a strategic element behind it, because we've heard many states saying pretty much exactly the same things on statehood, on continuity of states, and because I think, and some of them actually said that this is now emerging customary law, a new international rule. So having that first in writing and that putting it orally in front of the court is part of the emergence of law that we may see in front of our eyes.
The legal arguments were very compelling. The extent to which they will be brought into the decision, as you just said, will depend on whether the judges feel that they refer to the obligation of states to protect the climate system and everything else that is in the question. What you asked, Daniel, I think is really important. You know, who stood out, who didn't, for whatever reason. Now, obviously, what I thought, and I don't know if there are any students here, but from a student perspective, without telling you have to spend your Christmas holidays looking at it all again, by all means, don't do that. But actually, it was really fascinating to see the different styles of pleading. And also, if one thing comes out of this, actually, I was delighted to see so many new countries pleading for the very first time before the ICJ with their own counsel. Not, with all due respect, colleagues from London law firms or Paris law firms. And that to me is really interesting. The capacity building that this case has done to the legal profession in the Caribbean, in the Pacific, has been fantastic, and in Africa. Yeah. So that is something to be proud of. Not me, but you know, whatever.
The students.
The students.
Who initiate.
Yeah, the students who initiate, they should be proud of having snowballed this capacity. Specific people or specific countries, I mean, we can do it over drinks or whatever. I mean, there were a few that, I mean, just to name one, and I was literally listening it whilst I was going through an airport, let's put it like that. But Belize was one of two who brought a practical scenario in front of the court. Now that was tricky, because in a way, this is an advisory opinion where you shouldn't bring a bilateral situation. But I think, and I value very much the counsel who did it, she was very clear. And it really brought to life the connections and the legal points. That was very well done. Not the only one, but that's the one that springs to mind now.
On the nature questions, it was a really tough decision. Imagine, no? Me as a Director General of IUCN. I did it in my opening statement, not as I would have loved to do it, but we have to keep in mind that this is legal proceedings. So the judges will, you know, doesn't matter if I put all the red list of endangered species and explain about we are losing the corals, because what they really want to hear is the legal implications of all of this. So many other states mention, you know, the loss of biodiversity and everything that we are losing. But the precious minutes that we had to really address the legal implications of the climate change crisis. But as Christina just said, and Francesco, you can of course go to the detailed written documents. But it was not easy.
The 200 pages, are they online now?
Yeah.
Yes, since for an hour now or two.
Okay, so that's an important resource document. I want to move to the next two questions very briefly and then move towards the final remarks, because it's like, it's very late and you can always approach the speakers after this session.
So these online, I hope you don't mind if I take the second one from Gabriel. Gabriel and I have worked very closely together. I'm delighted to see that he's online and everything. The question there of Gabriel is very important, because it is, what are the implications of the decision? Will it lead to more dispute settlement, or will it strengthen and boost, as you said, the negotiations and the Paris Agreement process and other processes as well? I truly hope that it will do the latter, that multilateralism will come out stronger from this. But I also am sure that litigation will also be most likely boosted by this. My hope is that one doesn't go against the other. Only time will tell. But surely there's a lot of food for thought coming out, both from the proceedings and the decision that can lead to either one.
Yeah. The first question, I think, if I can't quite read it, was dealing with the question whether the court could actually look at regional human rights treaties, if I see it correctly, under the list of sources which the court can apply. And that list of sources just mentioned international treaties, and treaties under international law can be done between two states, can be bilateral treaties, can be regional treaties, can be those global treaties that we much talked about today. But it can also be a regional treaty. It can be a regional human rights treaty. So there is nothing that would prevent the court from going to the American Convention on Human Rights or the European Convention on Human Rights. Whether the court does that is a different question, because we usually have regional courts with jurisdiction over those treaties. But the court could do it. If they want to do it, it lies squarely within the sources that the court can use.
So there are so many questions. I'm trying to digest all this information. It's a lot, and I hope that was very useful for you. It's the second, I see you all nodding, so it makes sense. But for now, this is the second part of the event. We're closing the panel. I invite you again to approach the speakers if you want. But for now, we are finishing the event with the closing remarks that I think Daniela is going to
Together with Grethel.
Together with Grethel.
Yes.
Please, Daniela.
So Daniela,
Please, Daniela.
Well, maybe I can just close with thanking you very much for sharing your insights after such hard work, which is really a pleasure to listen to. Also, all the strategic choices that you have made for these proceedings. And of course, I can only echo Grethel. Let's hope, right, that this outcome, or that the outcome of these advisory proceedings are going to help litigants in their struggle, states finally understanding that they actually do have obligations. So I think in any case, we will have to be patient, of course, in a time, and of course, in relation to climate change, we always say, we're out of time, right? But still, let's hope within 6 months that the court will come with something that we can actually build on and work with. A final word of thanks, to the audience for being here, for sacrificing your Friday nights. Also to the online audience, especially for those diehards who are still here, because I think we started with around 50 and now we're back to around 20. Well, for those 21 participants that are still there, if you are not a member yet of IUCN and you are a lawyer, then apply for the World Commission on Environmental Law, engage and become a member of the climate specialist group, or my own group together with Karen Yoon on environmental security and conflict law. Thank you all for being here tonight, whether here or online.
okay.
Thank
you.
you.
Grethel, go
Let
ahead.
me just, before you applaud, to give a big thanks to Leiden University for receiving us, and to all of you, but also to the IUCN Netherlands Committee. And I have to say that if you participate in an NGO here in the Netherlands, join the IUCN National Committee, because it is very important, and we're members. We're going to have the World Conservation Congress very soon, next year, and it is important to strengthen our national committees. But big thanks to both of you, Leiden University and the IUCN Netherlands Committee, and of course to Christina, Francesco, and the colleagues in the IUCN World Commission on Environmental Law, and to my colleagues who I think are there, but everything that you have seen in the social media is these two ladies, Sue-Ann and Goshka, that have been covering IUCN during this day. So thank you to you. Thank you very much.